Yes.
Any mention from this?
My lord, can I request my lord to take up item 12 after lunch, post lunch? Will it be possible, my lord?
12.
Okay. Post lunch.
25. Huh? What is this?
My lord, it's a FR quashing matter.
Huh?
FR quashing.
Why it has come to me?
My lord, because it was listed before. Okay.
We'll see. I'll start. Let us see. Okay.
Item 51 on behalf of Mr. Funda, let it come 2 weeks after he placed the matter.
Which year?
51, 2007.
7.
Oh, 2007.
Item number 7, my lord.
Hmm.
I play for next Tuesday, my lord.
Let it be there. I'll accommodate you. Don't worry.
Because the file was missed.
I'm waiting for the report. Let us see the report. Let us see what report has come. Huh? Yes. Start.
My lord, in item 1, I have already filed my written notes of submissions. The state has also
I
filed.
have asked for a report.
My lord, the appellant number 1 had died. He has been, my lord, substituted in case that the appellants number 2 and 3 are the living wife and son. And I am appearing for them. I have filed fresh wakalatnama for which hearing was undertaken, my lord. So no report.
No report is required. Okay. Hearing is concluded.
My lords, I had placed it was only for my learned state to file the written note.
Item number 1's file has been not given. Actually, 3 files are there. So 2 files are given, though in another file, our written note of argument is there.
So then I'll pass it over. Just check it up. Huh? Pass it over because he has already argued. It is
But
urgent
it-
because of
Only thing whereabouts is to be
whereabouts now it is clarified. Whereabouts is not required. He is representing everyone. He has already argued the matter.
file.
That copy may be served so that if required, I'll file.
I'll solve during course.
Okay. Let it be passed over. We'll see. Yes.
Item 2.
Yes. 2, have you got any report?
Instruction is a 23. No recent instruction is there.
See, 97 matter, it was supposed to see earlier twice.
He is alive as per letter number. It is recent instruction.
July 25, first order was passed.
Yes.
We have that report. First July 2025 order.
Our letter has been sent on 7/2/2026 and instruction has been received.
So what is he doing then? Thursday.
Yes, yes, ma'am.
On 1/7/2025, the Superintendent of Police Bolangir was directed to inquire about the status, well-being and whereabouts of the appellant. However, report has not yet been received by the State Council. The matter was listed on 3/2/2026 and 10/2/2026. And the State Council sought time on for seeking the report. However, report has been received by him, hence he seeks the last opportunity. Release the matter on next day. Huh?
Report was available.
Okay. 92. 92. Yes.
Item 3.
Item 3 report is
Report is there. Where's the report? Since the order dated 10/2/2026, the IIC Bhartley PS Burgers has placed on record a report dated 11/2/2026 inter alia stating that the sole appellant, Bodhi Bala Sahu, is alive and is maintaining a normal condition. In view of all the same, the matter be listed for hearing. Hearing next week, next weekly. Report is taken out for yes.
Item 4,
4 is report is there. Item 4.
What report?
Your Lordship, on behalf of Mr. Jagabandhu, so may kindly be passed over.
Tikina and Nirma. On Tikina Sabu, alive, age about 82 and age about 82 years. Pursuant to the order dated 10/2/2026, a report dated 12/2/2026 issued by submitted by IIC JC Select PS has been placed on record. As per the report, the appellant number 1 is alive. She is 82 years of age. Whereas appellant number 2 is also, and appellant number 2 is also, appellant number 2 is the son of appellant number 1, who is about 40 years of age. There, and he is maintaining a good health. The appeal is ready for hearing. Yes.
item 5,
Item 5, report is not there. The last, it was in the last list 10/2/2026 number. For the first
10
time,
to 2026 order has not yet been complied by the State Council, and he seeks one more opportunity by way of last opportunity. 1 week time is granted. Yes.
item 6,
Your Lordship, I am appearing on behalf of Mr. Ajay Kumar Nandan.
Yes, got the report, sir. The report hasn't come.
file is allotted to is to
Same, same kar do. 1 week time is granted. Yes.
item 7,
Report has
Yes. 7, have you got anything?
allotted to Mr. Mohanty, his file is. One person.
Yes.
item 8,
8 I pray on Thursday. Thursday, I will get it back.
Okay. Thursday. Let it be there. I have just passed over for Thursday. Okay.
the 68,
Hmm?
the 68 report that's it.
Thank you.
I think 68 report.
All right.
Our diary for that.
No, order was passed considering their age, I called out.
68 will go to the report. Huh? 68. Okay. 68 kar do. Nobody is appearing. 60? Yes. Nobody is appearing. Whose Vakalatnama is there? Oh. It's not. Mr. Boss,
Well,
item 68 you have to assist. Mr. Boss, engage, report. Originally, the Vakalatnama filed by the learned counsel is has already been elevated in the judge since there is no appearance. Justice Sangam Sahu had filed Vakalatnama. He is now going to
Chief Justice.
Hmm. So Mr. Amit Bose will really report it, requested to assess the court.
I had the occasion when Justice Sau was elevated,
Hmm.
one of the briefs came to me. My lord, it was so, I'm grateful that he has so meticulously drafted. It took 10 minutes to understand the case.
The same thing might have been done here also. Give the file.
In the entire brief, my lord, he has these judgments which has been relied upon. What is the purport of that judgment? Why it is being, everything is meticulously.
He does that way. Yes. Next.
Item 9.
My lord, item 9, my lord, here your lordship may kindly recollect. The learned trial court, while convicting under 138 NI, passed an order, your lordship will see, 6 months for commission of offence under 138 and further directed to pay compensation of 2,30,000.
2,30,000.
It was confirmed in appeal. My lord also confirmed in the revision. Thereafter, an application was moved by my learned friend, Ms. Mahali, that he is ready to pay 1,15,000. 1,15,000 was deposited. The rest he is ready to pay. He has paid. I have received the check. Your lordship may recollect notice had gone because the brief was
Yes, yes.
taken up.
Yes, yes.
Note. But while disposing of the same, my lord may kindly turn to para 9 of that interim application 188 of 26.
188, huh?
This is the application filed by me.
Oh, yes.
My lord, in para 7, your lordship may kindly see.
Yes.
In view of the aforementioned
No,
developments,
you are talking about the order you have.
yes, that modified order.
Okay. That
My lord, order
dated-
dated is 16/1/26.
Okay, 9, yes. 7, yes.
Yes. In view of the aforementioned developments and regard being had to the fact that parties have settled their disputes arising out of 138, I recall the order. My lord, here my humble submission is, my lord, I have never considered there was a compromise. Because 1,15,000 was due, I took the money. But it does not mean, because your lordship knows nowadays we are more vulnerable to bar counsel. As a lawyer, we are more vulnerable to bar counsel. The clients immediately file an application before the bar counsel that I have never said for compromise.
Then see, once the money is paid and everything is taken by you.
Malab, even if money is paid, compensation is paid.
Sustained.
Because conviction is sustained because your lordship in a criminal, when your
It's a
lordship,
compoundable offenses.
Malad,
They have compounded.
Malad, that is up to your lordships to decide. But these settlement words, this should be removed. That will affect me, Malad.
Have you moved an application to that effect?
Yes, I have moved an application.
Okay.
Delete para
Because
7.
the compoundable offense and the money is already, compensation amount is already been paid. So the offense stood compounded, that's all.
Malad, that much if your lordship clarify, these settlements words are removed.
Okay.
Malad, I will be saved at least.
Okay.
Malad, your lordship knows nowadays,
Application moved by the, you are the
I'm the respondent.
respondent, oblique complainant, respondent complainant for modification of the order dated 16/1/2026. Mr. Bose appearing for the respondent, opposite party complainant, submits that the expression used by this court that the parties have settled the dispute had all potential to be misinterpreted by his client and he may be misunderstood as well. At the same time, he submits that indeed the entire compensation amount awarded by the trial court, confirmed by the appellate court, has already been paid to his client. But his client was never intended to settle the dispute. At the same time, and the same breath, he submits that the offense under section 138 NI Act being a compoundable
Well,
offense.
that portion,
It is a
your lo-
compoundable offense.
Well, yeah,
Compoundable offense.
it may be reflect,
It is left to
it
the
may
court.
be left to the
It is
court.
left to the court. On the permission of the court, the offense could be compounded. Could be compounded. The submission made by Mr. Bose appears to be genuine. He may be misunderstood by his client. Therefore, I intend to allow the application by modifying para 7 of the order dated 16 1, 2006. The para 7 of the said order shall read as under. Para 7 in view of the inverted comma करके, in view of the aforesaid development and regarding head to the fact that the parties regarding head to the fact that the compensation amount awarded by the trial court and confirmed by the appellate court has already been made good to the opposite party number 2, and this is a proceeding arising out of 138 Act, being and which is a compoundable offence. The matter stood compounded. Accordingly, the judgment of the appellate court dated 30th July 2013, passed in criminal appeal number 3 of 2012, is set aside. Set aside in view of the offense being compounded, and sentence is accordingly modified. इसको inverted comma करो.
Nowadays,
Observation, the application is.
nowadays, my lord, the problem is this.
I know. This happens. We have never settled the kind of thing. I clarified. Yes.
Item 10.
May I please, Your Lordship? The modification of order dated 24/4/2024, regarding extension of time. This order was passed.
What modification?
Any extension of time, my lord.
Extension of time. Extension of time till up till
24 मसीहा रे
28th. 28th of this month. 28th of this month. No further extension shall be.
subject to payment of some cost to the bar because 24 मसीहा order
Cost 8 lakh, 1000 ଟଙ୍କା ହେଇଥିଲା।
हजार
And 1,000 rupees already.
ପୁଣି 24 ସେତେବେଳେ 24 ମସିହା ରେ ହେଇଥିଲା ବର୍ତ୍ତମାନ 24
Petition is labor, my lord.
लेबर टू प्रभात जैन
Yes. Obligation. Yes.
Item 11.
Yes, sir.
Already
Item 11, my lords, Your Lordship, on the last occasion directed to file the compliance affidavit. Compliance affidavit, they have not filed, they are
you
furnishing the
got it?
instructions. I've heard that the order of appointment has been issued, but there is something, my lords, I would like to submit before Lordship, and I believe that Your Lordship will be satisfied that they have played the mischief. What I am saying, so Your Lordship may see the so-called affidavit they have filed. File was processed. Her husband was
Now the
my lords, Your
what is the
Lordship.
end result? End result is
1 minute, Your Lordship, may allow me.
Hmm.
Her husband was the assistant engineer. He expired in 2018, and thereafter she applied. She is a postgraduate in political science, the wife. She was having two minor children, and they have, my lord, so one of them has attained the majority. The case is that, my lord, file was processed. This case went up to Honorable Supreme Court. My lord, thereafter, after the order, the file was processed for giving her appointment against the class group C post. The Lordship may kindly see the last annexure of the.
Have you seen this complaint now?
I have not seen.
You see the complaint first.
Yes.
If
I'll-
grievance which you are raising, if
I'll-
it's addressed, then it's all
I'll
right.
file objection.
You,
Yeah.
without reading, you will file objection.
No, they'll solve
Your
it.
grievance might have been addressed also.
No.
How do you know?
I'll file my objection.
See, you are not
Copy.
filing any affidavit.
By way of affidavit,
Not
let them.
filing an affidavit or simply you file this.
comprehensive report.
Mr. Affat has filed a compliance. What is the compliance? And it's, got instruction from the engineer in chief, water resources department, dated 13 to 2026. 26, and placing the same report, placing the same instructions on record. He submits that the order enclosed with the report is the compliance of the judgment. Which judgment?
Let's your Lordship's
Compliance
order.
of the judgment sought to be compliance of the judgment dated
Your Lordship's order dated.
10 to 2026.
10 to
No.
26.
Lordship's order.
Passed in
Right.
so and so. No.
No.
Which is the contempt?
Repeat 12,
Which was it, the order?
12/9/2023.
12/9/2023 passed by this court in WPC number 2326 23/216 of 2021. It is taken on record. Copy of the instruction is also given to the council for the appellant. 6/110 to file response.
Yes,
Take it on record. File.
yes, sir. I'll file my copy to the,
Copy good. Yes.
or less.
Item 12.
Statement, please.
Yes, madam.
Request my lord to take it up after lunch, post lunch.
2 o'clock. Yes. Yes. Pass over. Yes, next.
Hearing.
Hearing.
Item 13.
13. Pass over. Yes. 13, you are there?
Yes, yes.
Okay. Yeah,
Lordship, the conviction under sections 451, 354, 325 of IPC and section 27 of Indian Arms Act, section 3(1) XI of the SC/ST Act, your lordship, and which is 7 years of rigorous imprisonment, madam.
Yes, madam.
My lord, I have prepared a short note.
Please keep.
Sure.
Let us do the short note which you have prepared.
Yes, your lordship.
Just run through. Date of occurrence is 92. At 5 p.m. accused boy Ellis entered the house of the informant at Bangasai, filed short injury, left hand short. FIR was registered on the next day. Medical informant onset injury. Police need to raise for seizure of gun. CI period was done, huh?
Yes,
Yes, it will be 25.
Okay, 26 prosecution witnesses are there
Yes.
and 2 defense witnesses.
451, 354,
Yes,
325. IPC's 27 arms.
27.
And SCST Act also.
Yes. Section 3.
376 and 307 equity.
Equity.
Okay. Okay. Custody, total custody period?
1 year, 4 months approximately.
1 year,
4 months.
4 months. Yes. Very good. Your written note is very exhaustive and very meticulous. Very nicely done. This should be the written note. At least you get clear idea about what exactly the case is. Have you given the copy?
Fine.
Yes,
Huh?
Your Lordship.
And I expect that this kind of written note is prepared, then lot of time is saved. Instead of looking into the file and all, everything she has mentioned. Yes. Yes, madam.
Yes, Lordship, there is a discrepancy in FIR and the PW1's deposition manner.
Hmm.
The discrepancy is that, Your Lordship, in the FIR, it is not mentioned, it is mentioned that when the sepoy entered into the hut of the Bengosai, Your Lordship, he first asked whether your husbands are there or not. But in the statement, it is different, Your Lordship. She stated nothing, she came directly and fired on me.
Hmm.
So this is one thing. It is already mentioned in judgment also, Your Lordship.
That discrepancy.
Yes, Your Lordship.
Hmm.
Then, my lord, if you may I read the PW1 statement? Yes.
Yes.
Deposition of. I'm not, and the most important thing is Your Lordship.
I'm not able to identify the.
Yes, Your Lordship. She was not able to identify the person who is standing on the dock, my lord.
Hmm.
And I am the informant in this case. And during this case, Kartika, this year, at about the day while I was working.
He's the informant and the injured victim also.
Yes, also.
He is not identified, first of all.
Yes.
Yes.
He didn't identify. And Your Lordship, one policeman also guarding media fired towards us, and bullet this near the left elbow joint of my left hand, and I sustained injury. Mark injuries is in the left elbow joint and visible, and witness is not able to stretch her hand, left hand, and being afraid of she rushed to the Kuttukudi, Your Lordship. That is the house of his neighbor house.
Hmm.
That may be 1 kilometer distance.
Okay, he ran away
Yes.
there. Okay.
She rode to that place. In the night, my husband returned to me and I narrated about the occurrence. Thereafter, I reported the matter to Gram Bikas people, and thereafter I reported the matter to PS. And examined the doctor, Your Lordship, the police. Here, Your Lordship, the cross-examination, there are 27 families in our village.
Hmm.
And my love, all houses are, my village is adjoining houses are there. The population of the village will be 50 to 60 at the time of occurrence, my love. And no one have heard anything about the occurrence. They did not, no one came to help the lady also, Your Lordship.
Yes.
And
Tonga Boda is at a distance of less than
yes, my love.
1 furlong.
That the area is an oxalate area. It is not. One more thing is that, Your Lordship, she said that the government has arranged police in Gangabada. It is not a fact that our area is an oxalate area. Once Gram Vikas people had alleged against the police, we got
compensation from the government.
Compensation from the government. This is a point, Your Lordship. By taking help of the Gram Vikas people, the connection with this case, I have received 10,000 towards compensation in this case from the government. And to help the Gram Vikas people, I have got compensation as Gram Vikas people told to report the matter, stating that I will get compensation. The matter was reported in the police. It is not a fact that there was no such occurrence has happened. My lord, here, Your Lordship, 10,000 is matter. 10,092 is some.
Huge amount. Yes.
Now, Your Lordship. So this can be a point, my lord, that the.
This FIR was registered only to get a compensation.
Yes, Your Lordship. My point is.
That's your correct.
And PW2.
Once Gram Vikas people had alleged against the police.
Yes.
We got the compensation from government taking the help of Gram Panchayat in connection with this case.
This case, Your
This case.
In this case.
Okay. Then your case is only to get that 10,000 rupees. The entire thing is cooked up against you.
Yes.
Okay. Yes.
Then PW2 statement is that, Your Lordship.
Yes.
The medical examination was held after 5 days on 23rd 11/92. The occurrence is 18. And the in FIR there is no raise of rape also, Your Lordship. They did not raise the rape part also, Your Lordship. After 5 days, the examen done.
Which one? PW2 you're talking.
Yes, ma'am.
Tadasi narrated the PW2 what he says.
I know the informant about 1 year, 6 months back, and about evening while the sun was in the sky. I was working inside the hut, and PW1 I was this so and so, and the accused present in the dock entered into that hut is with a gun immediately without telling anything to us. He fired
aiming at PW1.
And a bullet to her the left hand. PW1 sustained bleeding injury in left hand, and seeing the
She escaped.
escaped
Being
being
afraid.
afraid, and thereafter the accused got hold of me and made me fall on the ground and raped me till such and such, your lordship, ejaculated, and the semen adhered, and the cloth of the police during the investigation seized the same. Your Lord, and my MO3 is the blouse which I had used at the time of occurrence. Prior to commission of the rape, I protested saying to commit rape, but accused told that he would forcibly commit rape on me and thus threatening me be committed forcibly sexual intercourse with me. After commission of rape, I told that parents were
Near the-
near the hut. This is the thing, your lordship.
But
Then
this was not believed by the
yes, your
right.
lordship.
376 acquittal.
Yes,
Exactly,
acquitted
lordship.
because not corroborated by medical evidence, but that.
So it is this part of the evidence is not believed.
Yes.
This part of the
354
evidence.
is believed, your lordship, because 354 believed by the trial court that, your lordship, the ladies are Adivasi and the sepoy is a general caste. And he entered into the hut. That is the only reason. So then the court assumed that this such kind of things may be happened. That is in the judgment, your lordship.
Hmm.
So assumption is there. No proof, no direct evidence can prove that the whether the 354 is
Made out or not.
yes, or 372 is 376 is acquitted, your lordship. Then in cross examination also, your lordship. See, I also medically examined in the next day after the
Which para?
cross examination last, your lordship.
My parents are leaving.
Huh.
I have not.
Parents are living now, so the accused went to see the parents, my lord. Is this then that time I escaped? Then I narrated about the occurrence to my husband, and the matter was reported to Grambika's people. The matter was reported to the police. Police came and seized MO 1, 2, and from my position, then I was examined my medical officer in Parlakhamudi. I have attended TI parade. In the TI parade, I had also identified the accused present in the dock. He identified.
Then PW2 is not believed because somehow
Yes,
it's
yes.
not corroborated with the
Nothing.
yes. Let us see. Then
My lord, section 27 of Arms Act is also not applicable here.
let us go 3. Who is 3? What 3 says?
3, your lordship. The position of 3. PW2 is my wife. The husband of PW2, your lordship.
Mhm.
I know the accused present in the dock. I know the informant about the year of back and Wednesday.
The occurrence took place in my absence.
Yes. Date of
Date of
occurrence,
occurrence,
I
I returned to the
returned to the house at 5 to 6 p.m. My arrival, my wife told that she was working in the house of PW1 accused and entered into the
Hearsay.
house.
Hearsay.
Hearsay.
Yes.
PW3 and PW4 is hearsay. The wife,
Yes.
husband of PW1 is PW4.
Yes. Okay. PW5.
PW5 is the, your lordship, is the hostile witness.
Okay. Hostile.
5 and 6. 6 is the Pupudi Sabaroni, your lordship, the person.
Whose house she had gone?
If
6.
she went there, she stated that she turned hostile. As per the prosecution.
PW1 came to her house, but she says that PW1 and 2 came to her house out of fear. That part she has admitted.
Admitted.
Hmm.
And
PW1
she did not admit.
PW1 had a bleeding injury on the left hand, and she claimed they did not tell her why or mention police section and rape.
Yes, you know.
That part he is not, but he received the injury. That part is there.
Yeah.
Even if it is hostile, partly hostile. Partly. Okay. Next.
Then your lordship, PW7 is a seizure witness.
Seizure. Okay.
Seizure witness, my lord.
What? Seizure to what?
Towards the injury of
The police seizure metal alloy.
Alloy, your lordship. Articles.
Blouse. Okay. Confirm the accused was sepoy. Okay. formal witness, PW, PW9,
PW8, Subedar. He confirmed that, Your Lordship. PW8, madam. I know the accused, Pikesh present in the dock on 17/11/2. I was Subedar and Labanyan Gowda on OANAPP, anti-Naxalite picketing post. On 17/11/92, the platoon of a company came from Barampur. They the accused was one of the sepoy of the company on 17/11/92 at about 5 p.m. The company reached to our camp and reported me. As it was evening, the company could not be sent to Gangabada, which is at the distance of 35 kilometers from Labanyagada. So the company halted there for that night. One platoon consists of 3 sections, and each section consists of 10 members, including his 8 sepoy, 1 Havildar and 1 Naik. In the platoon, 28 persons had come to instead of 30 in that day, Your Lordship. One section consisting of a person was detained, and other 2 sections sent to the Gangabada. In those 2 sections, the present accused was one of the sepoy, some other ARs.
come to page 21.
21 years.
21. Doctor. What did he say?
Medical examiner, victim 2.
Examine. About 3.
Examiner.
No external injury was present over the face, chest, breast, abdomen, thigh, region, or both legs. Secondary sexual character was well developed. Absent. No injury was present. Private part, no. Original stage of process present. When the medical examination was done, 23,
12/1990.
when the incident taken place?
1811.
1811.
11/1990.
So then this report is neither here nor there.
Yeah.
No sign of recent sexual intercourse. The age of the victim is about 25 years according to the venture, but the final is also yes. Yes.
Then 11, the examination, 17 is the
Doctor who examined PW1
PW1.
injured.
17, huh?
Yes,
PW 17.
Para 2 is relevant.
The injury.
That is on 1911.
Yes,
Yes.
1911, 92.
Just after one day.
Yes, ma'am. Next day.
The injury is within 36 hours as per the medical officer examination.
Yes.
In Para 2, he has stated the injury firing distance is about 4 feet.
4 feet.
They have taken a plea of accidental firing.
Except your discrepancies in the evidence of the witnesses, what else do you have? These are discrepancies, or the trial court has taken care of the discrepancies, has analyzed everything, appreciated the evidence.
Your Lordship, the section 27 of Arms Act does not attract these punishment, Your Lordship. Kindly come to the section 27 of Arms Act. ma'am.
What is the sentence insofar as
It's been, what is
27 is mentioned?
7
Huh?
years.
7 years. Arms act then. Why it is not attracted?
It says about the license.
Hmm.
It's not about the punishment for the unlawful use of
25 and 27.
25 and 27. But here it is 27.
27.
Yes, ma'am.
Convicted on 27. 27 conviction.
Conviction and
One minute. Conviction on 27.
conviction under 27.
27.
Whoever uses any arms, ammunition, any contravention of section 5 shall be punishable with imprisonment for a term which shall not less than 3 years, but which may extend to 7 years, and so and shall also be liable to fine. Section 5 is saying about, Your Lordship.
License for many.
So for manufactured sale, etc., arms and ammunition, my lord. And 7 is also not same. Unlawful use of
Yes. So according to you,
yes.
the charges, because these people were holding the arms and ammunition which are officially supplied to them.
Yes.
So that way they were having license.
License, Your Lordship.
So
Okay.
use of those arm and ammunition will not attract 27. That's
27.
what you are trying to say.
They are licensed, and Your Lordship, that place is a Naxalite place, Your Lordship. So it is in the PW 11, Your Lordship. Here is stated that, my lord, before firing, it is when we are deployed sepoy into that kind of places, Your Lordship. Before firing, the order is not required. The gun is already on the bullet. Gun is already on open. What is that called?
Ready for fire.
Ready for firing.
It is fully loaded.
Yes.
It is always fully loaded.
Yes.
Yes.
And one was misfired, and the rest was submitted by the sepoy, Your Lordship, before the before.
Yes. So
And my lord, the,
even if 27 goes, the other offenses remains.
354 is, Your Lordship, judgment said that only the sepoy is a general caste and they are Adivasi. The two ladies are Adivasi. On that basis, and the judgment said that the footprint is there. Footprint is there, which was seized by
Which
the
paragraph? Let us see. So far as the third
Yes,
point
Your
is
Lordship.
concerned,
judgment part.
which paragraph?
And my lord said one thing that paragraph 10, page 12. what made the accused enter into the house of the innocent lady like PW1?
Paragraph 10.
Yes, you.
Question arises as to what? Huh?
Yes.
Page
Ye-
12. Page 12, paragraph 10. Starts from, but the question arises as to what made the accused to enter into.
the house and innocent lady PW1 and friend. In this connection, I am to share that it is admitted that PW1 and PW2 are Adivasi ladies and the accused of the general caste working in the responsible department of the OSAP. While all his friends were going ahead, this accused had entered into the house of one Adivasi lady and has fired under such circumstances. The alleged is not the accused committed the rape on PW2, but they said has not below duly proved. But from the facts and circumstances of this case, it is clear that the accused had entered into the house of the those ladies, outraged the
Either to outrage the
modesty of the
or to commit the rape.
commit rape. To be very clear, it is seen that the accused was on the time of occurrence, and from the conditions of PW1 and 2, it is clear that the accused no intention to loot valuables.
It's clear that the
no evidence to
accused
say
had no
that the
intention
accused
to
suspected
move the
the
valuable,
ladies
and besides there was no.
Slides under the circumstances and accused residing without his wife. This is the thing, Your Lordship. And camp and
Yes, yes, Mr. Panigre, what is the basis?
My lord, your lordship may kindly see the evidence of PW10.
PW10, huh? I'll just
Yes.
see. But he says that 376 is not believed. He entered into the house and fired one thing
Yes.
for that whatever offenses. But at the same time, he says the trial court says that his intention was not to loot or anything, but he might have gone for raping or outraging modesty.
the modesty.
That is a different aspect, but he has taken the plea of misfiring, accidental firing. That is not the case in view of the evidence of the doctor as well as the evidence of PW11 and 10. It is not a case of
No, there are
accidental firing.
segregate thing. Forcibly, the police troop was going. He remained in the back, and he forcibly entered into the house of PW 1 and 2 with that 2 and fire. And now there are 3-4 things happens. First of all, why he has entered into the house? One question. If at all he entered in the house, why has he fired? And what was the intention? The trial court says that he had no intention to loot, but he might have gone to rape or outrage modesty. In the same time, 376 ruled out not believe. 376 acquitted. So 354, how can you bring if the same prosecutrix version is not believed at all?
Using force against a lady also attracts 354.
No, that's right. But see, PW2's version is completely disbelieved.
PW1's evidence is there so far as firing is concerned.
PW1's first sentence of PW1 is, I don't identify these people.
PW2 identified and corroborates by
PW2 is not believed.
He missed the bus, reached belatedly, reported misfiring. And your lordship may kindly see
10,
the
you are
evidence of
talking about 10.
PW10 is the
Let us
another
see.
shipper. I know the accused present in the dock. On 17/11/92, we came from Barampur to Labanyagada and halted there. We 28 persons had come and reported our duty to PW8.
Who is this man?
He's another shipper.
Another
man.
Okay.
accompanied.
On the
On
next
the
day,
next day at about 6 a.m., we 19 persons, including one Jamadar, went to Gangabada. The accused had come with us from Barampur and he accompanied us to Gangabada as a shipper. On the way, we purchased our rations at
so whatever.
and returned to Sabba Kota from Mandusa. As no coolie was available, we cooked our meal at Sobba. Myself and Suren, after some time, got 2 coolies, and while we were doing with those coolies, the accused met us on the way. Then we 3 went to Gangabada. On the way near village, we took rest under a tree. There we 3 proceeded up to 1 kilometer, and there we crossed a nalla. And while I accompanied the coolie, the accused and M. Suren remained near Bengasai Ghatti. M. Suren joined me. The accused did not come. On being asked, M. Suren told that the accused was coming ahead of him, but he would not able to say as to where the accused had gone. We waited there for some time and called the accused by name with a loud voice. As accused did not come, we proceeded to Gangavada. At about 5:30 p.m., we reached at Gangavada and orally reported regarding the missing of the accused. At about 7 a.m., we reached Mandusa and we came to Mandusa by police vehicle. From Nandula, we went to Gangavada by walk. At about 5:15 p.m., we reached near Bengasai. Up to Bengasai, the accused was with us, and thereafter the accused was found missing near the village of the informant. Now, your lordship may kindly see PW 11. PW 11's evidence ruled out the case of accidental firing. It is not a case of accidental firing. I know the accused present in the dock.
Who is he?
He is the Jamadar.
Jamadar.
On 17/11/1992, I accompanied the platoon from Barampur to Lavanyagada. At about 4:30 p.m. on that day, we reported to duty at Lavanyagada. We halted there at night. On the next day, that is on 18/11/92, including myself, 19 persons were deputed to D. Gangavada. The accused was one of the sepoy of my section. We purchased ration at Mandusa and reached at Sobakota by 10:30 a.m. We cooked our food and arranged for fully. I took one Havildar and 4 sepoys with me to D. Gangavada in advance. Accused and others were advised to take the articles by arranging coolies. PW 10 reported me at about 5:30 p.m. that the accused was missing near Bengasai. I went.
I sent.
Sent. NS George, Havildar Sipo N. Aindi M. Suresh Sipo searched for the accused as that was Naxalite area. After some time, they returned and told me they could not find the accused. Though they searched Bengasai and other places, while I was taking further steps to search the accused reached at camp at about 6:30 p.m. On being asked, the accused told that he could not find the proper way to Gangavada camp, for which delay was caused in reaching. Besides, the accused told that one bullet had been misfired. While I told to give a writing to that effect so that I take action on the matter, the accused gave a writing to that effect.
Yes.
After receipt of report, I seized 19 rounds live bullets and one empty case and gun from the accused. At present, 18 live bullets and 2 empty cartridges are seen. MO so and so. Thereafter, para 4, my lord. On 19/11/92, 3 persons of Gram Vikas people and 10 to 12 persons of Bengasai came to my camp and reported that one of our sepoy had fired one lady. To ascertain the truth, I, along with 1/4 force, went to the spot along with police ASI Kepi Bhoi. I also marked the shoes marks of our sepoy in the village Bengasai, and on the way to Bengasai, I also went to the house of Sunari Sabburari. We also found one bullet sticking to the earth of the floor. MO, IV, A and B are the pieces which were found sticking to the earth of the floor. We also saw the injured and I found bullet injury on the left hand of injured Sunar. Then I requested the villagers to go to the PS and take immediate treatment of the injured. I also orally reported the matter to the Kepi Bhoi. On 20/11/92, OIC Gorabandha went for inquiry. The police seized guard diary, life cartridge, command certificate, and so and so. Thereafter, para 5 cross examination. For the first time, the accused had come to Gangavada. We take the gun in magazine position, and in that position, firing is not possible. If lock will not be opened and position of bolt will not be changed, the gun will be unlocked and bolt will be changed within 1 second. The SI of police Gorabandha PS had given him in writing to transfer the accused to Lavanyagada. We had given that letter on 20/11/1992. By that time, we were there to watch and catch the Naxalites. Without waiting for the orders, we can fire the Naxalite if we will suspect them as Naxalite.
Yes.
Some attack is evident on us.
No, what is your stand? Whether it is accidental fire
It
or
is not a
thinking that
case
they
of
are Naxalite you have
It
fired.
was in law.
You can't take both the stands.
Your lordship, whether the firing is done, firing has done from that gun, and the bullet which is hustled in the floor is the exact same bullet or not? That is there is no evidence they are produced by the police in the forensic report, Your Lordship.
My lord, he himself reported misfiring and
He is
empty
taking
cartridge was
to
handed over by him.
But there must be some similarity when the bullet is coming out from.
What is your 313 statement? What do you say? Let us see what is your stand. Whether it is misfire or you thought that they are Naxalites, therefore you fired. What is that?
The accused statement, Lordship. Accused statement is that, Your Lordship, he went for the nature of call, Your Lordship, for that when they all are coming.
But he says that I forgot the way.
Then when he came back, one coolie was there. He made her wait here. I'm coming. At that time, Your Lordship, the coolie was not there. So he got afraid, and on the slip of the boot, Your Lordship, the firing has done. That is the statement.
He is taking different story to justify it. But fact is, the trial court is that way correct that he might have gone to outrage the modesty or do something, and somehow it misfired.
The pellet what this PW 26 is said that, Your Lordship, he seized some pellets from that area, Your Lordship, and that area is used for NCC camp and also the police practice, Your Lordship. So the pellets may be from that guns or the bullets, Your Lordship. There is the ballistic discrepancy, my lord. It's not.
Question number 7 and 8, Your Lordship.
Yes.
Further, it has been evidenced that MO6 is an empty case which was seized from you. What have you got to say? 8. Also, it has been evidenced that on the way to Gangavada, you entered in the house of PW1 Sunari Sabar and without telling anything, fired of him, at the result of which PW1 sustained bleeding injury on her left hand. The micha kotha.
Question number 18.
Misfire which will report this.
हाँ से रिपोर्ट जाके देइछि सर. All these are, Your Lordship, the circumstantial evidence.
Question of misfiring ruled out in view of the evidence of PW11 at para 5.
Answer 24. Question 24 is answer. Their detailed answer. Just read it. What is
Will
that?
you say anything about the case?
Question 24.
Huh.
Will you say anything about the case? Separate. Come down. Move.
କ୍ୟାମ୍ପକୁ ଯାଇଥିଲି କିଛି ବାଟ ଗଲା ପରେ 4-5 ଜଣ 4-5 ଜଣ ନକ୍ସଲାଇଟ ଲୋକ ଗଲା ଭଳିଆ ଜଣା ପଡ଼ିଲା. ଭୟରେ କାଳେ ନକ୍ସଲାଇଟ ଆମକୁ ଫାୟାରିଂ କରିବେ ବୋଲି ଭାବି ଗନ୍କୁ ଫାୟାରିଂ ପୋଜିସନକୁ ଆଣିଲୁ. ତାପରେ ମତେ ଝାଳ ଲାଗିଲା. ଏମ୍ ସୁରେନକୁ ଟିକିଏ ଅପେକ୍ଷା କରିବାକୁ ମୁଁ ଟିକିଏ ଦୂରକୁ ଗଲି. ଝାଳ ବସି ଆସିଲା ପରେ ବେଳକୁ ଏମ୍ ସୁରେନ ସିପଏ ସେଠୁ ଖାଲି ଚାଲି ଯାଇଥିଲା. ହଁ, ଖୁବ ଭୟ ଲାଗିଲା. ତେଣୁ ତେରେରେ ତରତରରେ ଯାଇ ଦୁଇଟା ଗୋଡ଼ ଖସିଗଲା. ସେତେବେଳେ ଫାୟାରିଂ ରେ ହାତ ବାଜିଯିବ.
ଟ୍ରିଗରରେ ହାତ ବାଜିଗଲା ଆଉ misfiring ହେଲା.
ଫାୟାରିଂ ହେଲା.
Not possible.
Not possible.
The gun is always in lock position. They will never travel in a
But
box to camp.
that area is an Naxalite pro area, Your Lordship. Cannot.
He has stated that.
But see, that is clarified. You enter into the house where it was misfired. According to your own defense which you have taken, you had gone to attend the call of nature. From there you came out and you saw that Suresh is not there. You got frightened. Then you fell down. Your leg slipped. And as a result of which the fire has taken place. This is your case. How this has gone to their house floor?
Then, Your Lordship, where is the people who were 50 to 60 people are there who did not came out to help that?
That is a secondary, but let us understand your defense. Let us understand your defense. Your defense is this. Defense is not matching with the evidence of the witness.
Thing is that your lordship, the boot print. The
Boot print is there.
saying
In
that
the village, boot print is there.
yes,
And
sir.
you say that I had gone for call of nature, and you that there it is fired. So
That
all
is
these things are
the-
mixed.
And the
That
doctor's evidence shows firing distance is 4 feet.
That may be from any other gun, your lordship, because there is no
Confidence.
particular anything regarding the particular bullet, your lordship.
He has done it, but he's trying to, trying to make it up by so many things. Yes. Anything else? What is your answer to 27?
27, your lordship, may kindly see section 7.
Section 7.
Arms act, huh?
Yes, section 7. Section 7 say no person shall acquire, have in his possession or carry. There to be use, manufacture, sell, transfer, convert, repair, test or prove. Thereafter C, expose or offer for sale or transfer or have in his possession for sale, transfer and conversion, repair, test or proof any prohibited arms or prohibited ammunition unless he has been specially authorized by the central government in this behalf.
What she says is, I was posted in the Naxalite area
Now, the
and
gun
I was
used-
authorized, I was licensed,
Yes, he was,
so the arms act will not come.
he was,
Other offenses may come.
he was authorized to use the gun in self-defense, not to these innocent ladies.
So what is the offense under Arms Act?
So 27, he was not authorized to fire the innocent people.
No, he was authorized because he's from
He was
Naxalite.
authorized to fire at Noxals in the event of threat,
That is a
not to enter inside someone's house and
Suspect
shot
is-
at them.
See, if someone else's house he enter and fire it, the offenses are other offenses.
Yes,
House trespass and so many things.
that is
But
there.
not Arms Act. That's what the case.
Then also 451, 325
That
will
remains.
remain
That
valid.
remains. That's what I was telling you. Even if you have escaped from 27, how will you get over
354 is also not.
354 and 451?
That I have clarified already. In the event force will be used, that will attract 354. Somebody will open fire to a lady, it will attract 354.
Saying about the force. If force is with, indeed, your lordship, there is a injury. That injury, whether from that gun, that bullet, is not clear here, your lordship.
You should have been convicted for 323 or grievous hurt, no?
Grievous-
325 also.
325.
325 also, huh? Is
Yes.
there? You lost your job? Might have been lost. Convicted, huh? 325 is also there. How will you get out of 451? 354, okay. 354 goes in. 325 is also there.
See, your lordship, again, I will say the same thing. Whether that bullet belongs to that gun or not. The whole question is that why the police did not clarify? Because, your lordship, when this is not a private gun, your lordship. This belongs to a person who is.
Any ballistic expert?
No,
You-
No, your lordship. That part is not there. So what kind of injury?
In absence of ballistic report.
In absence of ballistic report, your lordship,
There is no ballistic report. There is no expert also.
yes, your honor. Only the PW 26 seized all these things, but no ballistic report is there. And the pellet is also not confirmed whether the pellet is of that gun, that bullet, or it's from
Apart
other.
from PW 1 and 2, who else has seen him in the village?
No,
No,
one.
no.
Then PW 1 and 2 and the boot marks which was found.
yes.
Boot
The-
mark is also neither here nor there in the sense. Whose boot?
Exactly.
How do you connect the
Because he was the only.
footstep of someone?
He was the only person who missed
The
other
boot
citizens.
is your lordship.
He himself reported misfiring.
He's agreed to misfiring, but not in this way, your lordship. Then he
No, it's a
submit
false
gun.
claim, my lord.
Then he submit his gun to the in the office, your lordship. how it is proved that that
And
bullet
one
Because
more
this-
thing, the problem is the PW2 says that this case was registered only to get that compensation of 10,000.
exactly
No, that's not correct.
exactly my
Yes,
lord.
But
to
you
you,
sustain a gunshot injury to get compensation, my lord. Way back in 1992.
And a knock slide was at that time very prone.
We were
at that
proceeding to a camp somewhere else. And he took a specific plea that he went to attend the call of nature, how the misfiring hit the injured while she was in her
There
house.
is no connection here.
She entered inside the Sahi to attend the call of nature. Is it possible, my lord?
Then where is the
It's
ballistic?
not a case that it is a false case. If he would have taken that plea, then the ballistic expert's report is significant.
These are all the circumstantial
He has taken
evidence.
the
There is no
plea of
direct
accidental
evidence.
Let us see. Then you can link him only through PW1 and 2.
1 and 2,
Isn't
10,
it?
11.
Let us read PW1 and 2 very carefully now.
Exactly.
If PW1 and 2 goes, then it's very difficult for you to connect him with the crime. Maybe whatever may be the crime. How will you connect him with the crime
She
if
identified
PW1 and 2 goes?
She identified him in the TI period.
No, just
Well-
see PW1 at the beginning it says, I am not able to
And-
Because
identify
FIR
the
against unknown person. FIR is very clear. FIR she has stated, I don't know that person.
She is not at TI parent. Who is the witness to TI
PW
parent?
25, PW2
25.
identified. PW2
Let us see.
identified in TI period.
PW?
2.
Two.
No, 25. Let us see 25.
25 is the magistrate who
Magistrate
conducted TI
who-
period.
Let us see.
Here she stated that, Your Lordship, that due to the poor eyesight.
Chief, come to 25 and para 3.
My lord.
Thereafter, the witnesses, Kumari Sabaruni was called for, and after that arrival, she was explained the fact to the conduction of TI parade, but she expressed her inability to identify the accused, stating in the time,
Standing in the line.
standing in the line due to
Poor eyesight.
poor eyesight. He was came to inside and jail presence. It was not visible to TI parade and other witnesses. There is a charge.
I changed the position of the suspects in the
Suspect.
line. I also changed the position of other UTPs who were taking part in the TI period. Thereafter, another witness, Behati Sabaruni, was called.
This
for-
is PW2.
Yes.
Yes.
Bebati
Similarly, she also explained about the facts of conducting TI period and was asked to identify the.
He has identified.
The
PW2
witness
has
identified the suspect PK Sadangi standing in the line, saying that the suspect had forcibly committed sexual intercourse with her in her house. No police persons were present near the TI period or at a distance from the place of conducting TI period. Exhibit 10 is my report and Exhibit 10/1 is my signature.
PW2 identified you. What PW says? PW2. MO2, just see, MO2 was sent to chemical examination. MO2. MO2 and MO3.
Yes, sir.
MO2 and MO3 is sent to medical examination. Take that part.
The ballistic report is not there.
That's
Now
there.
it
That's
is,
it.
MO2 and MO3.
No, MO2 is, see, MO2 is something different. Just see PW2. PW2 has cloth
Chemical examination report ଅଛି
MO2.
which has been stained with cements, and MO3 is a blouse.
Ah,
It is used at the time of occurrence.
that
Whether,
is not proved, Your Lordship.
see, that was sent
That
to
is
chemical,
that part.
because that part of the story is disbelieved by the trial court.
Yes, Your Lordship.
Nothing is there in the evidence of the IO.
See, what PW2 says that this accused entered inside the house without asking anything. He fired at PW1. PW1 sustained injury and she left. Out of scared, she ran away. And when she ran away, the accused forcibly committed sexual offense with this PW2. And the same PW2 in TI period identifies him. And that part of the version of PW2 is disbelieved by the trial court. So therefore 376 goes. So if PW2 goes,
Exhibit 9.
then the identification also goes. How the trial court deals with it, Shashi? But in that area, this is a common thing happening.
Yes.
There was a lot of resentment by the villagers, and there was rallies and all, because these police personnel, those who have gone from different parts of the country for the Naxalite movement, they used to exploit the village women and all. So that is the reason the Naxalite movement is increased. The women also become part of the Naxalite movement. This is what is happening.
Yes.
This is there. But that apart, how will you deal with it? Come to para 9 up to the impugned judgment.
R9
Para 9.
judgment.
So far, the fourth point is concerned. The FIR reveals that the accused inquire about the whereabouts of the husband of PW1 and PW2. And when they told that they had been to dig
Seen to
earth,
the
the accused tried to drag the hand of PW1, and PW1 protested. He fired towards her. But during the trial, PW1 has deposed that without telling anything
yes.
to them, the police fired towards them. Under these circumstances, PW2 corroborates the same and adds that while the accused without telling anything fired, PW1 sustained injury and escaped, and the accused cut hold of her and forcibly committed rape on her. Regarding the question of outraging the modesty and rape, PW1 and 2 are the main witnesses. And it has been held that the accused had fired at very close range, causing the injury on the person of PW1. And the accused is aged about 26 years, and is working in the Sepoy in 3rd Battalion of so on the way to Bado. He entered into the house of the informant, where no persons except
female
the another
PW2.
female PW2 was present and fired. And though PW2 says that he was forcibly raped by the accused, the doctor who examined the victim on 23/11
There is no sign of
11
sexual
p.m.
intercourse.
says that there is no sign of sexual intercourse. In this correction, I am to say that the occurrence took place also, and the examination of the victim, but doesn't show
No sign of recent sexual intercourse.
First one, sir. At about 1 a.m. Thus, the opinion of the doctor that there was no sign of sexual intercourse may not be conclusive, and this is unfortunate as to how such delays cause in the examination of so. So therefore, there is no sexual intercourse proved. Therefore, the court says that it is 354.
Yes.
Even 354 goes 451, 325. How will you get out of it?
451.
450 and
Yes.
entering in the house and firing, which resulted in the grievous hurt.
Yes, it is again, your lordship.
Offense one after another offense, we are crying.
That is, report is there.
The doctor says grievous injury.
Injury is there, indeed injury is there. I'm not saying that injury is not there, but whether that injury is from that bullet and that.
Why the see, the 11 people were in the TI parade, along with 11 people, this man was why the magistrate will tell lie? Magistrate identifies it.
that-
Even one has that.
There is the assumption part is there.
So the rape part goes, but identification remains. TI parade. PW1 has not identified you,
Yes, ma'am.
but PW2 has identified. How will you get out of it? How will you get out of it?
376 is not agreeing there.
376, even 354 also goes. Even then you are in.
Entering into the home, that doesn't mean, your lordship, the Adivasi ladies are there and that intention. And your lordship, judgment says that the Sipoy is staying away from the his house, your lordship.
See,
and why?
you have been sentenced to undergo 2 years RI for 451, for 3-1 XI SCST
SCST.
5 years. But SCST is not made out. Anything is proved.
No.
SCST is not made out. That has to go. Then at 325, 7 years. And 27, 7 years. 325, 27 also can go, but 325 and 450.
Sensibility report.
1 year undergone, huh?
Yeah, 1 year. Apparent.
What was his age that time? 26.
6, but in the examination by doctor, it may be 28 to 30.
Anyway, but 26 means
Yes.
he must be around
60,
60.
more than 56, 60.
Might have lost the job also. Huh?
Yes, your Lord.
Yes.
Now around 60 years old.
More than 60.
It is not possible.
If your lordship will give me some time, I can find out some judgments that this regard.
You have to concentrate on each offense.
Yes, ma'am. I'll find out some.
We'll
judgments.
continue Thursday. Because it's a very, see, if he's acquitted, he will get all benefit also. He will be
His whereabouts
reinstated.
are not known, don't know whether he was. Because the
Alive or not.
president only address is Noyagar. For that reason.
It's very difficult for acquittal. You can escape from 354 max to 27
that
Arms Act
injury-
also.
Whether that injury is from that bullet, where is the proof, your lordship? Did anything?
My lord,
That's-
he never
Problem is,
disputed.
you have been linked with the crime through
And-
TI parade. and T.I. parade stood corroborated with the boot marks. See, these are the villages where nobody goes with wearing those kind of boots.
Yes, sir.
Boot marks, and you yourself have said that I went there. So therefore, all these things proves that your presence was there in that.
Yes, your lordship. Even deployed.
And you have said that I have fired it, and the defense, if you would have said complete denial, it would have been far better for you. But offering conflicting,
one bullet is missed from
explanation.
that he has to deposit in the station, your lordship.
He did it and tried to justify by bringing different story, and that story is hurting you now. If you would have said complete denial, it would have been very difficult for the state to prove the case. But you have supplied the clue.
He
By
cannot-
taking
he-
those kind
he
of defense.
cannot lie on that part, man. Because every bullet they have to give
have
the
to
reason
explain
of
the
every
use of-
bullet, your lordship.
He wanted to save his job, basically.
Yes, you.
He wanted to save his job by after
No.
doing this.
Suspend.
So we'll continue parted.
Yes.
Thursday. Continue part. Get some
At
judgments.
this point, well, item 7 on the first of all, I have mentioned for an adjournment.
What happened? Report yet to come.
Next
yet-
week,
Yes,
next week.
report yet to come.
Next week I'll
Thursday, day after, I will forget otherwise. Day after.
yes, you.
Day after.
Okay.
And Mr. Panagirai, if you want to give a written note,
Nine.
small written note, give it so that we'll finish.
Nine.
Yes. Mr. Maharaja, which
Yes.
one?
Next one.
Next one?
Yes,
I'll just come.
Yes.
5-10 minutes. will do. Just period undergone and I'll just check it up.
Lordship, item 68, this is from chamber. My elder brother told me that amicus curiae is appointed in this item.
Item?
68.
Huh.
Uh,
95 matter, madam.
no, item 68, my lord.
60.
68.
Yes.
This is from chamber. My
You are appearing.
yes. No, this is from our chamber, your lordship. If your lordship, I'll pray for Thursday, it will come.
Okay, I have
I'll-
appointed Makishkuri. Okay, you to just
Amit Bosu.
change the order then. Huh? Somebody appeared and
I'll argue this
inform himself.
on Thursday, my lord. I'll argue this. And item 20, my lord. Item 20 also Thursday, my lord.
It will remain in the board. Remain in the board.
It will roll over. Yes, yes.
Yes.
Okay.
Yes, start. Yes.
Item 93, can it be taken on Tuesday, your lordship?
It is there Tuesday. We get ready and come and that begins. Yes. Please inform Mr. Bose. Yes. 14, huh? Yes. Yes.
May I start now?
Yep. 498A,
Yes, my lord.
section 4.
Yes, charge has been framed under section 498 304B 4 DP Act. Accordingly, trial started and the London Trial Court acquitted the accused from the charge under section 304B and only convicted under section 498 4 DP Act for 2 years, 3 months.
Yes.
Now, my lord, before starting this, my lord, the case on merit, my lord, I want to place the exact fact, what have been discussed in the judgment, my lord. Here, my lord, the deceased is the second wife of the appellant. Deceased is the second wife of appellant, and this elder sister of the first wife
Second wife of
of the
appellant.
appellant,
And
and the elder sister of the first wife.
Elder sister, sister of first wife.
First wife. But the first wife died
Hmm.
on account of illness, some serious ailment. That is why she died, leaving behind two minor sons,
Okay.
Bebina and
मंजुलता, मंजुलता। नहीं, लिखो PW1 Ramamani Jagdeep had two daughters, namely Sanjulata,
and Manjula.
Manjulata and
Sanjulata and Manjulata and Sanjulata.
Manjulata and Sanjulata. The appellant had married to Manjulata, and he had two children from this marriage.
Manjulata.
Manjulata unfortunately died due to prolonged illness.
Chronic.
Since one of the child born out of the earlier marriage of the appellant was suffering from polio, the mother-in-law, PW2, insisted the appellant to marry with the elder sister of Manjulata, namely Sanjulata. Sanjulata. the PW2 in the testimony has stated that at the time of marriage there was no demand of dowry, demand of dowry, demand of dowry. Sanjulata has expired. Therefore, the present case is initiated. In the next one. Ramamani Jagdev had married to, what is the name, earlier husband's name?
The second husband হচ্ছে কালু জগদেব।
No, no.
First husband is পঠানি রাউতরা।
Pothani Raut. Earlier married to Pothani Raut, right? From the said wedlock, two daughters, namely Manjulata and Sanjulata, were born. Okay. After the death of Pothani Raut, right? PW2 married to one Kalu
জগদেব।
Jagdev. Married to Kalu Jagdev. And from that wedlock, there is a son and a daughter born. Also. See, the property of Pothani Raut, entire property of Pothani Raut has been transferred by PW2 in the name of her second husband
Second husband and son.
And son.
and his children.
Son.
And his children. That was the bone of contention. It appears from the record that the appellant has insisted his wife Sanjulata to file a suit, exhibit 10 and 11, suit to claim the property. The suit has been filed. Which appears to be pending in determination. When the wife of the appellant died on that day itself, the summons of the suit was received by PW2. It appears from record that earlier the wife of the deceased had also filed a claim petition before the settlement authority, and however she withdrew the same. The trial court, after analysis of the evidence, returned a finding that in the form of money, the appellant has demanded dowry and demanded dowry from the informant PW2 in the form of the land, which is already transferred to the second husband and his children. And since the appellant has insisted his wife to file a suit, civil suit, claiming her right, claiming her share in the property, the trial court construed the same to be the demand for dowry. Yes. Accordingly, proceeded with the matter. Yes, sir.
We partner item number 15 and 16.
Are you ready?
I'm ready, but after launch, some other miscellaneous matters are there. So
Then
if
Thurs-
I'm available, I'll comment.
No, otherwise,
Or else-
Thursday is
I'll go first.
first item. Let us do it first. Thursday, first two items. Then you are sure that it will be taken up.
Yes.
First day रखते हो. कुड़ा रखते हो. Item 15, 16. 15, 16. Which year's matter? 95. Oh, very good. Both the matters, first and second matter, we will take 10:30. Thank you, Mr. Maharaj. Thank you.
Item 12. This is a case where one of the prisoner was serving in a company, one of the biggest exporter of Orissa since 2004. He tendered his resignation in 2024 January. Thereafter joined another company. There starts the dispute, madam. Now, after 1 year of his resignation, the earlier company, the first company he was serving, they filed an affair that some of the suppliers has given some money for buying some goods for the pit seller. Nothing, not related to anything to the company. And they frozen the account. Now they have also defreezed the account because they said that no, it is not required.
What are you seeking?
Crossing of the FIR, no case is made out. It is coming under the exception 2 of the that Bhajan Lal case. No case is made out.
What
As
is
per
the
plain
stage?
reading of
What
the
is the
FIR.
stage?
Your
State.
lordship has first, your lordship has disposed of first matter. You file all the documents before them. Let them take a decision so that there will be no problem. They can also discharge. Thereafter, my lord, they did not do anything. I approach again. And last date on
No,
11/9, your lordship
Charge has
has-
been filed, charge sheet has been filed, what?
That
is the stage?
instruction update
Your
CD was
lordship
called for
has-
Negarno.
to
Int.
produce the case diary and file a reply affidavit. So what is this case? When there is no offense against the company, he has not manipulated anything in the company. The offenses alleged is not made out at all. Because
Was
the
it
offenses
coordinate-
alleged is
See,
my lord.
Coordinate bench has directed
Yes, yes,
you to-
that's it. Before we may allow so 1 week time so that can comply that order. Order.
Because earlier he approached
Hmm.
and this court said that whatever document you are relying upon, go and give it to the
Yes,
IO.
right.
He will take into consideration. He has given it. Whether you have taken into consideration or not, nobody knows.
That chari order. Is there.
When the charge sheet is filed, then only we will come to know.
Yes.
Why have you come so early?
But the FIR lordship may see, there is no case.
That's right, but the charge sheet see,
But
earlier I
it
say,
covers on the Bhajan Lal case. That is why I have come. It covers under the Bhajan
in
Lal case.
first round when you came, that time also it was covering only.
This is
After-
no,
after
that time your lordship said that he will take a decision. But he is not.
No, I have not said take a decision. I said the document which you are relying upon, since the investigation is going on, give it to the IO. Let the IO deal it with it.
Chari
Yes,
25
let them
order.
file an affidavit. What they have.
Yes, but exactly whether you have considered or not.
On 26th, in between we'll collect it.
Okay, 26. Letter Counsel for the State seeks last opportunity to comply the order dated 30th
11/9.
October, no, 11/9.
11/9.
11/9/2020. Leads the matter on 26. 26. Okay. 20. Yes.
Item 70. May I please, Your Worship? Discuss my lord. On this under section 307, 5PC. Sentence to arrive for 10 years and pay fine of rupees 1,000 and default to arrive for 6 months. My lord. This case, my lord. Schedule 4 is injured, my lord. Case, my lord.
No, 1
Right.
minute, Mr. Goda.
My lord.
1 minute. Yes, you tell the facts. Thereafter, we'll start arguing. What is the prosecution case?
The victim, which is PW4, was dragged by the appellant Karan, and she was attacked by a knife, which is why the intestines, the small intestine came out. That is the prosecution allegation. Based on this allegation, the appellant was convicted under section 307 of the IPC and thereby sentenced to undergo 10 years of RI along with 1,000 rupees fine. That is the prosecution case.
Who is the injured?
PW4 is the
W4 injured, huh? And informant?
PW1.
Informant, huh? Doctor?
7.
W. Yes.
My lord. Here, my lord, the case. But at a glance, my lord, as page 15, FIR, my lord.
FIR, okay.
The according to prosecution alleged occurrence having taken place on 9/2/92.
Yes.
And my lord, the informant who is the father of the victim, my lord, injured, she lost the information on 9/2/92, but the same was received by the concerned court, my lord, STGM
12/2.
12/2, my lord. And that has been dispatched from 11/2/92, my lord.
Well, 11/2.
My lord.
11/2 or 10/2?
My lord, 11/2. But that has received by the concerned court 12/2.
Yes.
My lord. And with regards to my lord, scribe of the affair, my lord, on page 17, though my lord, LTI is there and some person signed, my lord, but they had not been examined in this case in order to prove the affair.
Yes.
And affair story, my lord, the father lodged information stating that he was present at the time of occurrence. He seen the occurrence while the he's also the statement of the evidence of the Pedal 1 and as by affair, my lord.
Yes.
He has seen the occurrence.
The informant is eyewitness.
See, he claims to be an eyewitness to the occurrence,
Right.
but in fact he is not an eyewitness to the occurrence. In view of the evidence of Pedal 4 is the daughter, and she stated that she was alone at the time when the accused assaulted the victim,
Okay.
injured.
Hmm.
But if her evidence is taken into consideration, then Pedal 1 is not present at the time of, though his lodged in the affair stated that he had seen the occurrence, and also his evidence stated that he had seen the occurrence. And the accused pushed him, that is their evidence, but this is the victim has not stated so. So, my lord, the victim evidence is concerned, my lord, at page 27.
Yes.
Paragraph 3. I was returning home from the house of the Sardar Mia after doing the menial work as a maid servant. It was night by then, and the light was put out. The accused confronted me near about a road crossing of the Basti, and gagging my mouth, she dragged me to a lonely vicinity of the Basti. In the lonely vicinity, she went to cutting me with a knife as a man cutting a goat. Again says, the accused went on stabbing me on a lonely vicinity, and the accused stabbed me to my neck, back, belly. The accused wanted to part with my morals. On my refusal, he went off stabbing me. Then the accused wanted me to drop me in a well to see that I could not come out of the ditch.
From the ditch.
The accused lifted me but could not throw me into the well. After stabbing me, the accused made up, and I returned to my house, pressing my belly. My intestine had come out as a result of stabbing. I can identify the knife with which the accused stabbing me. I returned back home and gave the statement of being stabbed by the accused before other members of the family. I felt unconscious.
She's a lady. She's a lady. Huh?
Lady, my lord. I took about 2 months to gain my sense. I have not examined by the police. My lord, she stated that she took 2 months to gain her sense, but she stated specifically that the police has not examined him. Her.
Because she was not in senses. Easily.
She stated that for about 2 months. Then cross-examination, my lord. There are cross-examination, my lord. But then, my lord, to the doctor's evidence. Schedule 7. On 9/2/92, I was attached to AC Medical Cuttack. Roji Khatun injured, aged over 16 years, daughter of such and such, PS such and such, and found the following. All the injuries were covered by medicaments and Nicopast. The patient was referred to SCB for a sub-regional hospital, from sub-regional hospital, Kendrapada, for the abdominal injuries. She was operated at 12:30 a.m. on 10/2/92. The
OT note reveals
OT note reveals multiple
small intestinal
performation as
perforation
Right.
at the side of one side,
One side
as was
restricted,
and
not visible, my lord, in my statement.
the patient was discharged on 22/2/1992.
My
When
lord.
the incident?
Incident, my lord, 9/2/92, and discharge, my lord, 22/92. That is 13 days. But she stated her statement, evidence that she remained 2 months.
She gained sense for 2 months.
My lord.
Yes.
She stated like that, my lord.
Hmm.
My lord, here is a case, my lord. My lord, in cross-examination, my lord, page 36.
Yes.
The entire bedhead ticket are marked as Exhibit 4. The bedhead ticket are in my handwriting, and the discharge certificate bears my signature. I have not submitted the injury report, my lord. My lord, case rests on this sentence only, my lord. My lord, here is a case, my lord. Basing on the bedhead ticket, the trial court committed the accused, my
No
lord.
injury report.
No injury report, my lord. I also, my lord, Schedule 6. He has stated in the evidence that he has not prayed for sent requisition for a injury report. No injury requisition, my lord, sent to the doctor, my lord. Here, my lord, this admittedly she has examined first at Kendrapada, my lord. But Kendrapada, there is no such doctor examined. In this case, no injury report is there, my lord.
Okay.
And basing on the evidence of Dr. Schedule 4 and Schedule 6 IO, this person has been, the accused has been convicted. Another thing, my lord, though the knife was recovered, the IO stated that at the instance of this accused, the knife was recovered, but in fact, that has not been sent for a SLF for a chemical examination. My lord, whether the blood stain found on the IO admitted in his evidence that he has not sent the
Who is
knife.
the seizure witness?
Seizure is in a PW, my lord, 2, he has not supported the prosecution case. He declared hostile. The, my lord, page 24. The accused and informant S.K. Dhuma are my co-villagers. Nothing was seized by police in my presence. On 11/2/92, at about 7 p.m. from the house of S.K. Dhuma, many days back, in a crowd, I saw the accused is grabbed and detained. Police reached at the place and asked me to put my signature on the piece of paper. I did that. As about the occurrence, I do not know anything. Exhibit 1 is the document where I put my signature. Exhibit 1 by 1, my signature again says the document was written when I put my signature. I could have no things post-occasion. Period 3 and period 5 post-occasion relative of the.
They've seen after the occurrence took place.
Pardon?
After the occurrence took place, she
No,
was
when
coming holding the
period 3 and 5. They are a brother and a sister of the injured. They stated that after when she went to the house, she narrated the story before them.
But they've seen she was coming out holding her belly.
Belly. That is it. They stated that like that. And PW managers 8 and 9.
What is the motive they say?
My motive, here when the case, my lord, motive is absent. To convict a person, my lord, intention and knowledge is plays the vital role, my lord. Here, my lord, intention and knowledge and the motive, my lord, totally absent, my lord. That part has not been taken into consideration by the trial judge.
What is the motive?
The motive, it has not been described anywhere else. But once a person was pick up somebody and cut his belly by way of sharp cutting weapons. Then motive is the presumption is always be true.
Eyewitness is there. motive.
Eyewitness. Motive is not required. Eyewitness is
Just just to know why he has done it.
See himself, my lord, see himself,
the
only except injured, there is no such eyewitness, my lord, to the occurrence. Though they specifically stated that some other persons gathered there, seeing the people gathered there, the accused fled away. But none of them has been examined in this case. And only Pidol 2 examined, he has not supported the prosecution case.
But see, informant says that I have seen it.
Though she stated that he had seen, my lord, but the Pidol 4 has not stated so that in front of the president at the time of occurrence or oppose the accused. And I read out the evidence Pidol 1, my lord.
no, it is not always seen that whether somebody is returning from his
My
workplace, that who is looking up,
At
staying
the
somewhere
time
else.
it says at the time of occurrence, I was returning home from the market. Near about a road crossing, I found the accused grabbing
The accused grabbing my daughter, whose name is Roji. On my protest, the accused gave me a push, and as a result of which I fell down, my lord. This part, my lord, has not been stated, my lord. The Pidol 4 not whisper anything, my lord, about presence of the Pidol 1. The accused lifted my daughter to the nearby place called Bari, where there is a well. The accused wanted to kill my daughter and dump her in the well. I chased after the accused and found him stabbing my daughter with a knife on her belly, neck, and a back. The accused wanted to cut the throat of my daughter, and with the knife he injured my daughter on the throat. I shouted at that at the inhuman action of the accused at my daughter.
That part of the evidence was never confronted with the IO.
When that he had, admittedly he has stated in the affair and in his evidence that he was present, accused pushed him and stabbed his daughter. But in fact, the daughter has not stated so, my lord. Though daughter was very much available, was present, but injured. My lord, if he injured, stated that my father was present and protested, man, that is a separate thing, my lord. Daughter has not supported the evidence of Pidol 1, my lord. When she opposed and accused pushed the Pidol 1, he fell down. That is not there, my lord, in the evidence of Pidol 4. So, has not been corroborated by anybody. And that part, my lord, in absence of injury report, my lord, bed had indicated only, my lord, bed had indicated so that date of admission, date of discharge, and a prescription, what type of medicine prescribed to the injured. And that part, my lord, no, my lord, the doctor has not stated anything regarding whether the injury is simpler or grievous, my lord. In the absence of that, my lord, one person can be convicted under 307, my lord. Though even if you taken to consider the evidence of the Pidol 4, my lord, it is a case that 307 at all not made out, since knife has not been sent for SLF. And also, my lord, the story of the affair doubtful and the affair with the police about 2 days, and after 1 day that has been sent to the court. Magistrate. So this story, my lord, it is entire case, prosecution case, my lord. And interestingly, my lord, the IO has not seen the bloodstained cloth of the victim. So also there is no such spot map, my lord. Latches on the part of the IO, my lord, the accused should not be, my lord, suffer, my lord.
You see, PW1 is very specifically says that I intervened
And he
pushed and went. And PW4, the victim, is not talking a single word about
even in presence of the Pidol 1.
But from the other thing, the victim statement is sufficient enough to convict the present person. Even suppose, my lord, he was dragged the victim. By that date, whether she was confronted with his father or not, that is a question. But that was not confronted with the IO. That part of the evidence was never confronted. So victim statement is clear. And your lordship may kind of glance to page 33, the IO, there he has went to SC Medical College and collected his bed ticket and everything. These are all the documents are also available on his record.
That is only bed ticket. nature of injury might not known to anybody. Doctor has not stated about the nature of injury, whether it is grievous or simple. And another thing, my lord, that a weapon of offense has not produced before the doctor. I have not sent for chemical examination, whether blood is found on the weapon of offense or not. And PDO 2 has not supported the.
And when repeated stabbing and everything was going on, what she says, where the father had gone? Father has not received any injury.
No, father not received. He stated that he was
Para 729, come to page 29. Para
pulled.
PW.
The accused lifted the doctor and
Stop
nearby
near-
place, and the
No, no.
accused wanted to kill.
Para
my
7,
father.
page 29. Please.
My lord.
The shops near about the place of occurrence were open. When I called for the outsider, after the accused grabbed, the accused kept me grabbing near about the road
About
crossing for
200
half an
to
hour.
250
For
people gathered.
half an hour. About 200 to 250 persons gathered at the spot after they heard my shouts, but no outsider intervened. I did not try to get out of the hole of the accused. After I made shouts, Sardar Mia and their family members reached at the spot. I could not identify the persons who came around me, as it was dark night and there was no light. I had lost my sense after I fell down. After I regained my sense, I managed to run to my house. The witness speaks in an inadequate way. After I went home, I relayed my story to my mother, sister,
I lost my senses
my lord.
after I fell down. After regaining my senses, I managed to run to my house. And now come to page para 4 of previous page 28, examination sheet. I returned
back home and gave the
statement
statement of being stabbed by the accused before other members of my family. I felt unconscious. I took about 2 months to gain my sense.
That means what she is trying to say is,
My lord.
when she received the injury, she became unconscious.
Unconscious.
He gained conscious, came and narrated everything, and again got unconscious and regained after 2 months.
2 months.
But doctor says after 13 days she was
discharged.
What is the
That there's some minor inconsistency may be there. Whether the fact remains, whether the injured was sustained injury and by sharp cutting weapon or not. That's the question. After exam, at that time of examination, some minor inconsistency may be there, but that cannot be a sole ground to reject all those statements made by the before the court. The IO himself has also collected the bed ticket and other things and produced before the court.
Let us see the exhibits.
So even if assume for the moment the defect in the investigation cannot be a ground to disbelieve the entire story of the injured witness at least.
Nature of injury not known, my lord. The doctor has not stated whether injury is grievous or simple, my lord. In absence of that, my lord, the one person can be convicted under 307, my lord. In order to bring the section under 307, intention, knowledge, and also the motive is, my lord, plays a vital role, my lord. Here, my lord, motive is absent.
Motive, nobody is saying anything.
Anything, my lord. And though the independent witnesses are present, they have not been examined this case. And mother also withheld, my lord. She stated that I told the fact before my mother has not been examined. Scribe has not been examined. And the clothes of the victim, those my lord, bloodstained clothes, that has not been seized by the IO. There are many lacunas, my lord.
Para 3 of the IO, page 33. The injured was Roji Bibi, was the daughter of the informant Dhuma Khan. The accused tore upon the belly of the injured with a knife and had cut her throat. The injured somehow or other got escaped
and cut her throat. That's not the case.
The injured somehow the PW4 has stated some other part also got injured, sustained injury. Lonely vicinity, the accused also stabbed to my neck, belly, back. That is the suitable for
That's right.
obstructed.
Where is the cutting of throat?
That part has not been
So
read
therefore,
upon.
therefore the inconsistency in the nature of injury, which part of the body it caused, and all these things is different. Witnesses are saying different things. Therefore, the medical report was essential.
Right.
To set it.
That is not.
Yeah, medical report is there. They also-
No, medical report nahi. Bedded ticket
No,
only.
that is
Bedded
something has
ticket.
been described there, man.
देखो.
Page 34 paragraph 8 my lord.
Discharge certificate is there.
Discharge certificate कहते 22 दिन 13 दिन 22 तारीख discharge 9 2 रे admit ହେଲା 22 2 रे discharge कर देले.
Operated on 9/2/1992.
And the interestingly,
That page
preliminary
57.
doctor has not been examined at
Page
the,
57.
who treated first the injured. He has not been examined.
Come to the exhibit. What is this? Is again multiple steps.
Page 57 mechanical glass.
Bedded ticket only.
Operated on 9/2/92.
Exhibit 4.
4/1 there. Signal. One of the there is an injury on abdomen, neck, and hand. That is mentioned at page 59.
OT note is there.
Forwarded from Kendrapada Repository, Rojikan, such as some
The
data. print-
discharge certificate, everything is there. Discharge certificate is exhibit.
The injury
Exhibit 4.
related injury, abdomen, neck, and hand. That is mentioned. So corroborated the injured statement also.
Nature of injury, my lord, is silent, my lord. But the fingers are simple.
Merely the sharp cutting on belly and is always it is better.
And the interesting, IO, my lord, paragraph 8, page 34, cross-section stated that again says the weapon of offense is forwarded to the court. MO1 is the knife which I seized from the accused after the accused led me to place of recovery. The weapon of offense was in police station till charge sheet was filed. Thereafter, the weapon of offense has come to court Malkhana through Kendrapada police station. But though the weapon of offense seized, the police kept with him till submission of charge sheet. Has not sent the same to for criminal examination. And Pedal 2 has not supported the case, my lord. only prelude to, even if evidence of prelude 4 taken to consideration, including the my lord, doctor, my lord, then my lord 307 is not my lord attracted in absence of injury report.
And what will happen to discharge slip?
My lord,
Discharge slip.
discharge slip, my lord, there. And my lord, interestingly, my lord, the first doctor who examined the injured, he has not been examined in this case at Kendrapada.
Very badly conducted.
My lord, I had not seized the bloodstained clothes of the injured. And spot map, no spot map is there, my lord.
How much you have undergone?
My lord, at the time of my lord, he has arrested on 28 11/2/92 and bail out 26/8/94, 1 year 6 months 15 days. Again after judgment, 25 days. Total 1 year 7 months 5 days. She has also, my lord, what a decision, my lord. There, the Honorable Appellate Court, 3 judgments, my lord, recently stated that in order to prove a case on motive, intention, and knowledge is required.
The 307, it will not so much attract because if it is murder, something otherwise.
307. This is
There is a case of 307 and a knife injury also there. Trial court acquitted. High Court reversed the judgment. Supreme Court again acquitted. Set aside the order.
which paragraph?
What day?
11, 12.
Citation.
11.
Citation.
Read 11.
Madam.
Read, madam. 11.
Thirdly, there seems to be consequential disparity in the.
13. You are reading 13?
Your Lordship, para 11.
11. Okay. Thirdly.
Consequential disparity in the oral evidence adduced by witnesses, the medical reports and the opinions in the terms of the nature of injuries suffered by Matthew and Imran. Specifically, it is undisputed that the injuries suffered by the victims were not caused by lathis or a blunt weapon. Similarly, the evidence regarding the placement and extent of knife injuries sustained by Matthew and Imran does not inspire confidence. Hence, the questions surrounding the use of lathis or knives have undermined the prosecution case, just as they have cast doubt on the extent and nature of injuries sustained by the injured witnesses. Fourthly, and most importantly, what makes the circumstances entirely murky is the fact that the FIR itself was lodged by a hearsay witness, namely PW1 Farzan, who is Imran's father. Notably, Farzan was not present at the scene and only learned about the incident through alleged eyewitnesses Jakir and Irfan, both of whom had accompanied Imran and Mathu when the latter were allegedly attacked by the appellant and other accused persons. Ironically, there is not even a whisper of alleged eyewitnesses, Jakir and Irfan, joining the investigation. These persons were apparently ghost witnesses who neither did their statements recorded by the investigating officer under 161 of the CRPC, nor were they produced by the prosecution before the trial court. Similarly, no attempt was made to record their version under Section 164 CRPC. The discrepancies elucidated above could have been clarified with ease had these eyewitnesses been produced or their statements recorded, shedding light on the sequence of events as they unfolded. The deafening absence of these 2 alleged eyewitnesses in our considered opinion has considerably weakened the prosecution case. Usually in matters involving criminality, discrepancies are bound to be there in the account given by a witness, especially when there is conspicuous disparity between the date of the incident and the time of the deposition. However, if the discrepancies are such that they create serious doubt on the veracity of a witness, then the court may reduce and decline to rely on such evidence. This is especially true when there are various evidence tendered by the prosecution witnesses regarding the sequence of events as they have occurred. Courts must exercise all the more care and conscientiousness when such oral evidence may lean towards falsely implicating innocent persons. Undoubtedly, there are glaring interludes which severely enfeeble the case that the prosecution sought to present. The prosecution's story has been demolished by the oral testimonies of the witnesses, including the medical experts, coupled with the contents of the FIR registered by a hearsay witness. It goes without saying that the chain of evidence proffered by the prosecution has to be as complete as it is humanly possible, and it does not leave any reasonable ground for a conclusion consistent with the innocence of the accused, and must instead indicate that the act had indeed been singularly committed by the accused only. To further fan the flames, there is no motive attributed to the appellant or his co-accused, Bhola, in order to justify their conviction under Section 307 of the IPC. Both the injured witnesses, Imran and Mathu, during their cross-examination, clearly explicated that there was no enmity or ill will between the accused persons. It is not even the prosecution's case that this was a chance occurrence. It seems that the accused and the alleged victims were familiar with each other and had some kind of association. This is thus more to this than meets the eye, and we are not entirely convinced of the narrative presented and perceived by the prosecution. In our considered view, the High Court ought to have been given due weightage to the glaring inconsistencies before reversing a well-reasoned order of acquittal. It is well-established canon of law that the trial court has acquitted the accused based on plausible understanding of the evidence, and as such finding is not marred by perversity or due to overlooking or misreading of the evidence presented by the prosecution. The High Court ought not to overturn such an order of acquittal. We are inclined to hold that the trial court, after reviewing the entire evidence on record, was correct in concluding that the totality of circumstances casts doubt on the alleged incident and suggests that the prosecution witnesses may have concealed the actual story. We thus find it quite unsafe to convict the appellant on basis of such.
So therefore, it says that if there is consistency and when there is no motive, apparent consistency are there is no motive, nature of injuries are not known, then relying upon the evidences of the prosecution is bit doubtful. That's what the
But here is something, the nature of injury, there, here also the London trial court at page 9. Just they are giving their observation something, their findings.
trial court.
Page 9.
Okay.
Occurrence took place substantially the father of the victim was the informant for the prosecution. Case is a story of love, anger, and revenge leading bloody consequences.
9, huh?
9. The internal page 3.
Yes. Para.
First para, bottom. Occurrence was first.
Occurrence took place in the evening in front. So, father of the
Case is a
victim was the informant of the prosecution. The case is a story of love, anger, and revenge leading to the body. Where is the
There
where
is no
from-
such evidence. Where from the
where
get
from
my lord?
this?
Then a lordship may kind of glance that page 11 that London trial court has escaped.
Huh?
The doctor para 9.
Pity for the
Prosecution
prosecution.
said there is
Is that
no
there
injury
is
report.
no injury.
The doctor examined PW7 testifies fact that when he attended Roji Bibi in the medical, the injuries were covered with medicaments and Nicoplast. The doctor found the followings. All the injuries were covered by medicaments and Nicoplast. The patient was referred to SCB for Sub-Division Hospital Kendrapada for the abdominal injury, and she was operated on 10/2/1992, just after 1 day. So once there was a serious injury, belly was seriously injured. The operation was 9/10/1992.
No,
That
injury
was
is,
supported by
injury is not doubtful. Injury, but whether
injury sustained by the accused is also not doubtful, not controverted. The two things: the injury sustained by the accused by weapon of offense, that is knife. That the next para. Exit for the report of the doctor. He has said about the confinement of the Roji Bibi, the bed for about the fortnight. All the injuries done by Roji Bibi are the effect of spring knife, MO1, that is recovered from the recovered by the IO from the accused. So the knife which was used to sustain injury, caused injury to the
that was kept with IO for
Submit charge till submission charge
How can
sheet,
you
I
keep
kept
it?
the same. And PDO 2 has not supported with regard to seizure of the knife.
He has
And
kept
whether-
it for such a long time. He himself
That
says.
knife has no link with the, my lord, the injury, my lord. As well, that has not been put to the specific question, my lord, not put to the doctor, my lord. That are not produced before the doctor. Whether this type of injury caused by this type of person.
At the oral evidence and medical evidence. If both are to be equated
Do not
with each
tally.
other, the oral evidence will always be prevail over the medical evidence.
Oral do not tallied with the, my lord, the medical
The
evidence.
injury is, he has, victim has injured, has sustained the injury on vital part. That corroborated the medical report of that operating portion of that medical report.
Not medical,
Even
bed
take-
ticket only.
No, bed ticket that mentioned,
Can't
the
be-
injury is here mentioned, operation has been mentioned. Part of the injury, back, neck and a belly. Even taking into granted there is no independent corroboration, I hold the prosecution case reasonable proof with the what there is a record. The doctor, the knife, the victim, the father and the relatives said about the brutality of the accused and the serious effect of the action on the life of the person. On my part, I wonder how a woman survived with the multiple injury and with the opening of her belly by a knife which forced out, intention came out. The defense advocate has run best exhaustive cross-examination, inviting to that grains when separated from chaffs make prosecution reasonable proof. The injured is the best witness who has examining has given the vivid description how the injury has been sustained by her and for which the present appellant victim is the author of the crime. We are some sort of discrepancies or PW1 stated that my daughter with a knife, belly, neck, and back. PW4 injured stated so. The doctor also stated that the injury and part of 3 parts that is mentioned in the bed ticket while produced. Exhibit 4.
Where from he got this this story of love, anger, and revenge?
That is not there in the case record, my lord. Nobody stated like that, my lord. Even in the family members and the outsiders.
I have said.
No.
Where from he got it? I don't understand.
That is not, I have not stated.
You can't
Nobody
presume things in criminal this thing. You have to see from evidence.
evidence.
He has cooked up some story, built up some story regarding.
Only to, you know, to convict the
And
accused,
the
my lord.
trial court just see the judgment. The trial court is not very cryptic order.
He determined to convict the accused.
Huh?
The language used by the
Three pages.
trial court.
Very ornamental language.
Ornamental language having no basis.
From the beginning, he determined to convict the accused. Nothing, my lord.
After all, you are
No
convicting
material,
him.
my lord, at all.
The material is
For
there.
10 years.
Material is there. The injury is not doubtful.
Material is not coming out very clearly. Therefore, with ornamental language, he tried to justify by putting things on the mouth of the.
My lord.
That's correct. But so far injury sustained is not doubtful, is not controverted. So the present accusers of injury with the author of crime is not disputed. These two things is to be bear in mind by this.
Not supported by any other.
Inviting 10
There
years.
is no other person was
Ulterior
there
statements, but
with
maximum.
any other things. No other person was there with any other weapons other, so that things would have been something otherwise. There is no defense also is there to
And so many latches on the part of the IO, my lord. For that, the accused should not be suffered, my lord. On the latches of the IO, prosecution.
Defective witness cannot be a ground to disbelieve entire story of the prosecution if the victim, the injured is himself or herself being the examined and detailed description is given.
Actually, this appeal is pending since 95.
95.
Otherwise, this is a case for remand, basically.
At this
Trial court has not dealt with anything. Very unfortunate. But remand at this stage is.
After lapse of 30.
What is the age of this boy?
under 19 years at the time of murder, judgment. And victim is 16 years at the time of judgment. Or evidence matter at the time. And he must have been murdered, leading a happy conjugal life and remaining murdered.
Nobody knows.
But so that in 19 years old, but that time murdered.
19 years old.
Maybe now 49 years perhaps.
19 or
Maximum 49 years.
But the injuries are very, very serious.
Serious, but
The intestine came out of this.
But that is one of that is the evidence of the Procedural 4 and the doctor who restrained the IO and the doctor not to give the
That's
injury
right.
report.
But see, the problem
And nature of injury not
IO has
mentioned.
boast of everything.
And
IO
nature of injury has not been mentioned. Whether grievous or simple.
Nothing is there. But see, for 307, nature of injuries are not necessary.
Even if injury not there, they can ballot.
Takes it to bodily cause. Even if it is simple injury,
But
then also 307 can be made out.
But three ballot ingredients has to be fulfilled ballot.
Hmm.
First ballot, that the death of a human being was attempted. Second, that such death was attempted to cause by or in consequence of that act of the accused. Third, that such act was done with the intention of causing death, and that is was done with the intention of causing such bodily injury. A, the accused knew to be likely to cause death or was sufficient in the ordinary course of nature to cause death. Here, though the doctor has not stated the injury is sustained by the injured, that is sufficient to cause death in the ordinary course of that is not there, my lord. That is not there, my lord.
Intention came out. That's why the learned calculator luckily has.
That the accused attempted to cause
No, no.
death doing an act.
See, unless you say that the injury caused, the doctor should have said
Say.
that the ordinary course is to
Nature it is sufficient to cause death.
nothing.
That is not there, my lord.
Evidence is
At
not
least
there.
that part should have mentioned, my lord, in the.
Therefore, even if you convict a 10-year sentence in this kind of evidence, it is a case for remand. The trial court to reappreciate the evidence by setting aside. But at this stage, what to do? See, reduce the sentence, something up.
And 1 year, 7 months, that.
See that. Give a written note. Give a written note. Huh? Argument here. Hmm?
And she will submit on first.
She will say. Heard Mr. Ragada, amicus curiae, along with Mrs. Chetana Prakash, advocate, and Mr. Mohanty for your state, and judgment reserved, and parties are the parties to file written note of submission. Chetana, you do it.
She will submit, my lord.
She will do it.
Hon'Ble.
Anything is there? Yes, item 1.
Already submitted below, and I have a soft copy. Written note of argument.
Once I have received his written note of argument.
Item 1. Written note of submission.
Yes, my lord.
What the written note of submission has been submitted by both the parties. Matter was already heard.
May I recapitulate if
No,
your
no,
lordship wants?
I'll do.
Because one of the witness has one of the accused has in the meantime expired. If at all any allegation, direct allegation regard to demand, it was with the late. And accused number, appellant number 2 and 3, 2 is the wife of appellant number 1, while 3 is the husband.
Indramani died.
Yes, my lords. And
Sarita Naik and Pramod Naik.
admittedly, the doctor.
Sarita Naik is also, that time he was 65, 95.
Bedridden, my lord. She is still alive.
It's only now think for Pramod Naik. that's all.
Pramod Millets, I am pressing it because he is still in service. and ipso facto there is no allegation with regards to torture or demand. Because evidence of prosecution witnesses have been to the effect that Pramod was never present during the time of dowry or any demand or nor any specific torture said to have been meted out by Pramod or Saria in that respect.
Evidence is there. Evidence is underlined. Yes, get the evidence. In all the matters where I visual visually get the evidence. Okay, thank you.